I welcome you all to lecture number 2 of family law. Okay, now in the previous lecture, we discussed that marriages are prohibited in you cannot marry when you are falling in prohibited relation to each other. Okay, now let us see what are those prohibited relationships. Okay, prohibited relationships in which Hindus are not allowed to marry. Okay, these are those relations in which you are Hindu is not allowed to marry, and if a Hindu is marrying in this prohibited relationship, okay, marriage would be illegal. It would be void ab initio, right from the beginning. Such kind of marriage, such kind of union will be unholy. Okay, will be illegal as well. Lineal ascent. If one is lineal ascendant to other, that means lineal in the straight line. Okay, you are straight line, you are ascending from the straight line. Like mother and son, they cannot marry. Father, daughter, they cannot marry, and so on. Okay, grandfather, granddaughter, grandmother, grandson, something like this, they cannot marry. This is a prohibited relationship. Affinity. If one is the husband or wife of the lineal ascendants or the descendant of the other. Example: father-in-law and daughter-in-law, mother-in-law and son-in-law, stepmother, stepson, or stepfather, stepdaughter, etc. Affinity means marriage. So affinity means relations which are set up by marriage. Okay, so if a relation is set up by marriage, other correlatives cannot marry. Like a father-in-law cannot marry his daughter-in-law. Now, what is the relation between these two? They are not lineal ascendant of each other. Okay, but they are related by affinity. Father-in-law, she is the wife of his son. He cannot marry his son's wife. He cannot marry his daughter-in-law. Mother-in-law cannot marry his son-in-law. He is the husband of her daughter. Okay, you cannot marry your stepmother. A Hindu cannot marry his stepmother. Okay, though this mother has not given birth, but she is wife to your father, wife to a Hindu's father. So a Hindu cannot marry the stepmother, or stepmother cannot marry stepson. Okay, like this. Wife of certain brother relations, such as brother's wife, mother's wife, father's brother's predeceased brother, etc. You cannot marry certain wives. Which wife? You cannot marry your brother's wife. Okay, you cannot marry your brother's wife because usually in Hindu law, okay, wife of elder brother is considered like a mother, wife of younger brother is like a daughter. But in Haryana and Punjab, if brother has died, okay, then another brother could marry such widow. Okay, as it is the custom there. So, like I discussed, that these laws are there, but if a custom allows some practice or some community has its own practice, then those practices will also be followed. Close relations, such as brother and sister, they are close relations. Niece and nephew, niece and uncle, nephew and aunt, children of brother, sister, children of two brother, children of two sister. Okay, these are certain close relations which are prohibited to marry each other. That is why they are called prohibited relationships. Okay, they cannot marry. Adopted sister or adopted brother. A Hindu is not allowed to marry the adopted sister or brother because he or she is also considered a part of family just like these close relations. Hindu Marriage Act makes such ceremonies void. Okay, these ceremonies are void. If you enter into these relationships, these are void and as well as they are punishable. Okay, however, such marriage remains valid if local custom allows such practice subject to validity of such custom. Okay, marriage between a person and his eldest sister's daughter is common in many parts of Tamil Nadu. Like marriage between a person and his eldest sister's daughter. So they are uncle and niece. Okay, now their marriage is okay in some part of Tamil Nadu, but it is more of a traditional practice in Tamil Nadu. Modern people do not follow. Modern times people now are not following this practice so many occasions, but traditionally this have been the case in Tamil Nadu and people have followed such practices and they were allowed as well. Now, Sapinda relationship. If we go to our previous class, we discussed that you cannot marry if you are Sapinda to each other. Now, understand what is Sapinda? According to Mitakshara, Mitakshara and Dayabhaga we discussed are two school of thoughts, and we often go back to them to understand what is the meaning of some particular term. So law does not define sapinda, but we go and we see in sapinda mitakshara that what is a sapinda. Pinda means particle of a body. A man is prohibited from marrying a girl who has the same pinda in her body. Okay, that means you cannot marry a girl or a boy who is having same particle of body in her body as you are having. Okay, so now you must be thinking how a boy and girl who are not related to each other they can have particles of same body. Okay, we'll understand. Those related by blood or consanguinity are considered. Consanguinity means blood related by blood are considered to have the same pinda in their body. So blood relations are supposed to carry same pind in their body, same body particle. HMA limits the extent of Sapinda relationship to 5 degrees in the line of ascent through the father and 3 degrees in the line of ascent through the mother. That means 5 degrees from father side and 3 degrees from the mother side you are prohibited to marry. Okay, you are prohibited to marry. Suppose this is a subject. This is a person who wants to marry. Okay, and he wants to marry a female. So they are not having any lines below them right now because they are unmarried, they do not have children. Okay, these are father mother. Okay, these are father and mother. Okay, but we do not have any children right now, so we cannot go downwards. We'll always, when we are considering sapinda, we'll always go upwards. So this is she is a female, red is male and this is a female. Okay, these are the subject, one male and this is female, they want to marry. Okay, now sorry, this girl she wants to marry, she is the first generation. Now what is the second generation upward? Her father, her mother. Then we'll go three line to female. Okay, first line is her mother, then her mother's mother and mother's father. Okay, then grandmother, great grandmother, great grandfather. Similarly for father, one, two, three, four. These are ancestors. Okay, these are ancestors. Now he wants to marry a girl or she wants to marry a boy. Suppose here is a boy, and his father's line, his father's this line is somehow clashing with this line. Okay, somehow you see that this female she wants to marry another male, but ultimately on four generations above they are having one ancestor as common. Okay, they are having one ancestor as common. She also has this great grandfather and he also has this great grandfather. This great grandfather is common for her and for him. Okay, or she has a great grandmother from mother's side, and he also has a great grandmother from her father's side. Okay, this is common. Then you cannot marry. Then you are called to be carrying part of same body. Okay, part of same body. When you have a common ancestor, okay, you have a common ancestor, you cannot marry. Okay, so common ancestor does not mean brother, sister, and etc. No. Okay, you can have, see, family trees grow very large. Okay, these people, suppose they had four sons, one, two, three, four. Okay, then he would have another two, three. Everyone is having two more kid. One, two, one, two, one, two, one, two, and then it goes on like this. Okay, so family trees grow very large. So somehow people standing here after six generation, they are usually not aware of this person, that this person also had the same grandfather, I also had the same grandmother. Okay, so but law says you are considered as sapinda, you cannot marry. Okay, but we have limited it, we cannot keep on counting till unlimited number of times. It says for father's side we are watching six generation, for mother's side we are watching only three generations. Okay, seven and three, sorry, 5 and 3, it is like this. So you cannot marry if you are having a common ancestor anywhere in 5 generations from father's side and 3 generations from mother's side. Essential ceremonies of Hindu marriage. What are the essential ceremonies? Okay, what ceremony a Hindu is required to go through in order to conduct a marriage, and if these ceremonies are not conducted, marriage will not be a valid marriage. Under the old law, before passing of Hindu Marriage Act, a marriage was duly solemnized only when the nuptial ceremonies essential to the validity of marriage were performed. These nuptial ceremonies essential to valid marriage are, these ceremonies were marriage essential for marriage. Okay, Vivahoma. What is Vivahoma? Vivahoma is simply invocation before sacred fire. So whenever Hindu marry each other, okay, they always do it in front of fire, and we treat fire as sacred. Okay, so we have fire, we light a fire, and we perform a yagya, that is called Vivahoma. That is the name of the yagya. Homa means shlok. Okay, Homa means sacred hymn. Homa means sacred hymn. Sacred hymn. And Vivaha is marriage. That means sacred hymn for marriage. This is first invocation of fire. You invoke fire and you chant hymns. What hymns? Hymns for the marriage. Then Satpadi, it's also called 7 steps. Okay, 7 steps or 7 rounds across fire, etc. Kanyadan, gifting the bride to groom by bride's father. Handing over the girl to groom. This is done by father or some other elder. Okay, these are the essential ceremonies of Hindu marriage. Okay. These are essential where no ceremony is prescribed by community, custom, or usage. Suppose there are those Hindus now which do not know what ceremony to follow. They are not having any custom or usage in their community. Okay, they are not having any traditional ceremony. So, what ceremony should they perform in order to call their union a marriage? So, law says you can perform these, you have to perform these three things if you don't know. But if you know some custom and you have some custom, then you can go for your customs. Like in Tamil Nadu, in some places, merely uh, putting Mangal Sutra around is sufficient for marriage. Or somewhere, some places in country, merely putting vermilion, sindoor in the forehead of the girl is sufficient for marriage. In Punjab, Haryana, you marry each other just by putting a wheel on the girl. You take a piece of cloth, a man will take a piece of cloth, a dupatta, and he'll put it over the girl, and that will be a sufficient form that will be a sufficient marriage. Okay, so if you have some customary marriages, you perform your marriage as per your custom, no issue. But if you do not have such ceremonies, any uniform ceremony, then you perform these ceremonies. Okay, these are the essential ceremonies of Hindu Marriage Act. Void and voidable marriages. Like we discussed, void and voidable means in the Contract Act we discussed. Void actors legal and cannot be regularized. It cannot be regularized. It's void. It's bad per se. Right from the beginning, it is void. Voidable means one party has option to get marriage declared as void. Like in the voidable contracts we discussed. Okay, that avoidable means avoidable. You can avoid it. One party can avoid it. Okay, the one party who has suffered some loss can avoid that marriage. This is called voidable marriage. So void marriages, a marriage becomes void ab initio. When? When would a marriage in Hindu law will become a void marriage? Let us see when a marriage in Hindu law will become a void marriage. A marriage where spouse, living spouse. There is living husband or wife for either party to marriage. Two people are marrying, but one of them is having already a spouse which is living, and their marriage is also subsisting. That is why we are calling him a spouse. Otherwise, we would have called him ex wife. We are calling ex wife or ex husband. We are calling spouse. That means they are still married, and then the person is performing a second marriage. Then this marriage will be void. Second marriage is not allowed. Okay, second marriage is void. You can just say second marriage. Sapinda, when parties fall within Sapinda relation, and we just discussed Sapinda, five ancestors from father's side, three ancestors from mother's side. If two people are having any common ancestor anywhere within these relations, then you are following Sapinda, you are sharing particles of same body. Some ancestor has been common. Okay, then you cannot marry. You are Sapinda. And if you marry, you are Sapinda if you marry because this is actively prohibited, then that marriage is going to be void marriage. But if your custom allow you to do so, okay, if the usage in your community allow you to have more than one spouse or you can marry in Sapinda, then you can do so. These rules are for those people which do not have such custom or usage. If you do not have such custom or usage, then you cannot do so. If you have some custom or usage, then you can definitely do so. Prohibited relationship we discussed. Okay, so in these cases, if you are marrying in these three situations, either of them, any one of them, or two, three more coming together, then even one is sufficient to get the marriage declared as a void marriage. Voidable marriage. Now, voidable marriage means a marriage which can be avoided by one party. One party has the option to either to treat the marriage as a valid marriage or to get it declared void. Voidable marriage which can be annulled at the option of one or both the parties. A marriage becomes voidable on the following grounds. Fraud. Okay. Consent obtained by the fraud or force. When the consent of the marriage is obtained by force or fraud, then the party whose consent has been vitiated such can get the marriage declared void. Unsound mind. Incapacity to consent or suffering from a mental disorder. When someone has married someone who is unsound mind, okay, then the person who has married the unsound mind, he or she has the option whether to treat the marriage okay or not. If they wish to get married to an unsound mind, no issues, no one can stop them. But if they do not want to remain in the union, they can get it terminated. Pregnancy, concealment of a pre pregnancy. The woman is already pregnant. Woman is already pregnant at the time of marriage. Pre pregnancy does not mean that she had been pregnant sometime. She had been pregnant before marriage. No, it's not. Okay, the father, the husband, has no knowledge that the girl I am marrying to is already pregnant, but the child does not belong to this present husband, and the husband is not aware of this pregnancy at the time of marriage. If he is aware that she is pregnant with somebody else's child, then also she goes on to marry with his knowledge, then he cannot later on claim that it is a void marriage. Okay, if he was aware and he still chose to marry, then it will be a valid marriage. But if he was not aware and the child is not his and he was not aware, then it will be a void marriage. He can get the marriage declared as a void marriage. But in case he wants to continue in such marriage as well, if he wishes to continue with such marriage, then he can continue with such marriage as well. No issues. Okay, he can continue. Impotency. Okay. Inability to consummate owing to impotency. One party to the marriage, either female or male, is important to marriage. Okay, they are important. They are suffering from impotency. Impotency is not no capacity to bear child. Okay, no capacity to bear child is not impotency or sterility. If the woman cannot be a child, suppose she is not having any uterus or there is some physical ailment, she cannot be a child, or there is some deficiency in man. Okay, he cannot uh, like he is also important. Okay, but he is not having quality to give birth to a child. Then that is not the importance. Which this is not we are talking about importance. Importance means inability to engage in physical relationship. Okay, that is the inability we are talking about. It can be mental, it can be physical, but merely not able to bear a child is not impotency. Marriage of minors is valid, it is voidable at the insistence of contracting party who was minor at the time of marriage. Now you must be feeling that what I am teaching you right now. Marriage of minors I am saying valid. Yes, a minor's marriage is valid. Okay, valid. Minors getting married is valid, but there is a law. But there's a law which punishes such marriage. Okay, Child Marriage Prohibition Act. But that act only states that if there is some child marriage being conducted somewhere, then police can get the marriage stopped. Okay, and police will punish those people who are arranging such marriage. But if the marriage is conducted, if the marriage is performed by the minors, okay, okay, the people have organized their marriage and marriage is conducted, then the marriage is valid. Police can yet punish those people who have got this marriage conducted, but marriage is valid. Okay, marriage is valid. And in such marriage, which is a minor's marriage, okay, when these minor who are married, they will become adult, they will have an option whether they want to continue in such marriage or not. Okay, otherwise the marriage is going to be a valid marriage. Now we have discussed marriage, Hindu, and let us now discuss what is how a divorce is happening in Hindu law. What is the rule of taking divorce in Hindu law? Section 13 of Hindu Marriage Act deals with the divorce. It talks about dissolution of marriage. Under Hindu law, divorce does not take place unless it is been granted by divorce. So divorce has to be granted by the court, otherwise divorce will not be a valid divorce. That means panchayat or community divorce is no divorce at all. That means you are in a village, you marry, and marriage is not working. Then elders of the community, we call them panchayat, and I don't know what is the parallel word in Tamil language, but you understand what I am saying. Village gathers, sarpanch or the head of the village and elders of the village say that you are divorced now. This kind of divorce is not a valid divorce. We do not follow such divorce. We follow rule of law, and so rule of law says every divorce has to happen through the law. That is through the instrumentality of court. Now, what are the grounds for divorce? These are the grounds which are section 31 HMS says. On these grounds, both spouse can take divorce from each other through court. Infidelity. Spouse had voluntary sex with third person after the marriage. Either spouse, man or wife, they are caught having sex with any other person outside marriage. Okay, that is called infidelity. If some spouse is guilty of that act, other spouse can claim divorce from the spouse. Okay. Adultery. Spouse is living in adultery. Adultery means again the same thing. Just like infidelity, infidelity is something occasional cheating, but this is like you are permanently living with someone else. That term is called adultery. Okay, you are living with someone else. Then other spouse can take divorce on this ground. Cruelty. One spouse treats another spouse with cruelty. Okay, and cruelty can be both physical as well as mental. That means you are torturing the wife, you are harassing her for dowry or this and that, or you are beating her, you are alcoholic, or one is taking drug and not taking responsibility. Something like this. Mental harassment is there. Okay, pattern of behavior that cause reasonable fear of harm from other party can be construed as cruelty. Cruelty includes both physical injury and mental agony. Cruelty again is a term which cannot be defined. Okay, cruelty depends upon the case to case basis. So harassment, if you are cruel to your wife, you are beating her, or your wife is beating the man or something like this, then other spouse can take a divorce. Desertion. Desertion comes out from the word desert. Desert means alone. Okay. Desertion of the spouse means one spouse has left the other spouse alone for a period of not less than 2 years. Okay. For more than 2 years, other spouse has left her, left him. Okay. Both physical separation as well as animus decidendi, intention to end cohabitation must be proved to establish desertion. Desertion is that she or he, one spouse, willingly left the other spouse for more than 2 years. It is not merely a physical separation, but intention to stay away should be there. It is not that one is posted somewhere and doing duty there. Okay, one is in military. He is stationed somewhere, or someone is working overseas in America for 3 years. Last 3 years, she is there. Then you say that she has deserted me. No, this is not the kind of desertion we are talking about. Not physical separation. We are talking about intentional separation, where she is separated from you willingly. She may be living in your neighborhood, next house to you. Okay, but she does not want to stay with you. That is the desertion, and if it happens for more than 2 years, then you can claim divorce on this ground as well, that my spouse has deserted me. Because what ultimately marriage is union of two people, that two people should remain together. If two people do not want to live together now, okay, they have no intention, one spouse has no intention to live with the other spouse, then what is the use of continuing such marriage? Such marriage should be buried. Okay, so we are going to bury such marriage, and this is will be a ground for divorce. Disappearance, you have become invisible. If one spouse has a civil death, someone has died civil manner, okay, that means not been heard or seen for 7 years. Someone went away, now there is no communication. Nobody knows where the other person is, and it is like this for 7 years. Then the law presumes that such person has died. Okay, that such person has died. Nobody, no relative, has any information about the person. That person boarded a train to go to Mumbai, but he did not drop down at Mumbai. Okay, and we do not know where he dropped. And it's been more than 7 years. Nobody has heard about him or seen him. Okay, then this is a civil death. Then, if someone has died a civil death, other person can take divorce. Mental insanity, unsound mind, mental and physical illness. Someone has become insane after marriage. Okay, then you can take divorce. That other spouse has become insane or unsound, mentally or physically. Okay, he has become unsound. That means he cannot perform the duties of a husband or a wife. Then you can take a divorce. Leprosy is a disease. Leprosy is a disease which spreads upon touching. You touch a person who's leprosic, then you are also, there are chances that you may also contract the disease. However, there are very less cases of this disease in India. We have now removed this disease from the root. Okay, vaccination and medical standards are high, but still, if someone is having such a condition, that if someone remains near that person, the other person will also contract a deadly disease. Then this is that case, just like COVID-19. Virulent disease, if the spouse is suffering from communicable virulent disease. Okay, virulent disease like HIV/AIDS. Someone is having such a disease that if you cohabit with that person, the disease will transfer to you as well, and the disease is deadly. Okay, other important thing is both these disease, leprosy and virulent, should be such disease which cannot be cured. If the leprosy can be cured, then you cannot take a divorce. You will have to take the cure. It's 1 o'clock. If a virulent disease can be cured, then you cannot take a divorce from your spouse. You will have to get the spouse treated. But suppose he is having HIV/AIDS, which we have no treatment right now, then you can take divorce. These are the cases. Renouncement. If the spouse has renounced the world by becoming a sannyasi and entered into religious order, he has renounced the world or she has renounced the world, that I have nothing left in this world. I'll go to the jungle, I'll do the meditation, I'll do yoga, I'll worship God, and this and that. Okay. Conversion. If the other person has ceased to be Hindu, if someone has converted to Hindu, then you can take a divorce. But these renouncement and conversion, these two grounds, these grounds are available to only to the spouse, which is the other spouse. Suppose a man and a wife. Wife says, I will renounce the worldly order, I'll become a sannyasi. Then she can become a sannyasi, no one can stop her. And husband can take divorce. But women cannot say simply because I have become a sannyasi now I'll take divorce from my husband. No, she doesn't have that right. This right is available only to other spouse. Conversion right is only available to other spouse. Man says I turn to Islam. I have become a Muslim now. I am no longer a Hindu. I have become a Christian. So women can take divorce from such person, but man cannot himself go to the court and say that I have embraced Christianity. I am no longer a Hindu. So on the ground of conversion, you give me divorce from my wife. No, this cannot be the case. Okay, if this is allowed, then people will abuse this provision. If someone wants to divorce from his wife or husband, he will simply turn to some other religion and take a divorce. No, this is not the case. Okay, other spouse has a right. This is the right applicable available only to the other spouse, affected spouse, not the spouse which has acted. Okay, living separately for a period of continuous 2 years. Okay, like it is just like desertion. You are living separately for a period of 2 years without any reason. Then you can take divorce. Now, these are the grounds which are common to all, 11 grounds, which are common to both husband and as well as to wife. But law provides some additional grounds to wife. These now grounds which we are going to discuss are available only to the wife. Bigamy, if the husband is getting a second marriage done, okay, after marriage, has husband has married another wife, then the wife, earlier wife, first wife can take the divorce. And even if the second wife, she is not aware that he is already married, she also can take divorce. Okay, for first wife, the marriage will become voidable. For the second wife, if she is not aware of the marital status, for her the marriage will be void. Okay, but this is not a ground for husband. Husband cannot say, okay, this is not ground for husband, it's only for wife. If wife is marrying another husband, okay, marrying another husband second time, he cannot take divorce on the ground of bigamy. He can take divorce on the ground of adultery or infidelity or desertion as well. But he cannot take divorce on the ground of bigamy. This is applicable only to the female counterpart of marriage. Rape or sodomy. If the husband is guilty of committing rape or sodomy, okay, sodomy is unnatural rape. So if a wife or if a husband is guilty of committing rape, because a women cannot be guilty of rape, women cannot commit rape. So this is ground applicable only to a woman against a husband. Okay, husband cannot say my wife has raped someone. Okay, wife cannot rape. So husband is guilty of committing rape. Okay, then she can take divorce from the husband. Okay, bestiality. Bestiality means entering into sexual relations with animals. Okay, this is also a ground for the wife. Underage. If the wife was below 15 years of age when marriage was solemnized, she can repudiate the marriage and file for divorce before attaining the age of 18 years. Okay, if the wife was below 15 and she was married, she can take divorce. Okay, even if she is more than 15 but below 18, then also she can take divorce. Hindu Marriage Act recognizes divorce under customary law. Such custom and usage should have been continuously observed for a long time, having obtained the force of law among Hindus in any local area, tribe, custom, or group. If you have some customary way of getting divorce in your community, Hindus, then they can have divorce from that in that manner as well. Okay, but if there is no customary divorce available in your community, then you have to find your case somewhere. Okay, now you must be wondering that sir is saying if wife was below 15 years of age when marriage was solemnized, she can repudiate the marriage and file divorce after attaining age of 18. Okay, and then he is again saying that even if she was above 15 and below 18, then also she can take the divorce. Then why I have written it so this? Because act has written it like this, but judicial pronouncements, we discuss sources of law precedent. Okay, judicial pronouncements now say that court orders, court judgments are such which say that even if she is above 18, below 18, then also she can take divorce. Okay, and a man also can take divorce. This is not the ground in HMA, but law says so, court says so. If a man was underage. Now we'll discuss the provisions for children and maintenance. What is the position of children in a Hindu family and maintenance? What are the provisions for maintenance in such families, in Hindu families? Okay. Section 26 of Hindu Marriage Act and Section 38 of Special Marriage Act empowers the court to pass orders and make provision in the decree regarding custody, maintenance, and education of minor children. Empower court to pass order. When court will pass order, that means a matter has reached to the court. Spouse are taking divorce from each other or staying separate from each other. Then these are the provisions in which court can pass order. Court can pass any order regarding custody that children will stay with the mother or the father, okay, or they will jointly hold the custody, or they'll keep on meeting each other like this. And maintenance that father should pay 5,000 rupees per month or 10,000 rupees per month as per the status of the parties, financial status of the father, financial status of the child, age of the child, requirement of the child. Okay, different parameters are there. That father has to pay this much maintenance. Court has power. Court can direct the father that you should pay money and you should provide the education to the minor child as well. Okay. In general, courts tend to award physical custody to the parent. Court will award physical custody. That physically child will stay with which parent. Court will decide upon these parameters. Who demonstrates the most financial security? Who is more financially secure, father or mother? Okay. If father is more financially secure, court will be more lean to granting the custody to the father. Why? Because raising a child needs money, and if mother does not have enough money, then the child's growing up is going to suffer. So court will say for the best interest of the child, the one who is more financially stable should have the physical custody of the child. Adequate parenting skills. Who is having more adequate parenting skills? Suppose the father is alcoholic. Father is alcoholic, druggist, or he's into gambling or bad habits, then we cannot say that father is having adequate parenting skills. Such father cannot be said to be having a adequate parenting skills. Or suppose mother and father there is a dispute and mother is physically ill, so she also cannot be said to be having a adequate parenting skills. So it all depends on these things. Cause the least disruption to the child. Okay, we'll send the child to that parent. Okay, staying with him will cause least disruption to the child, and that could be the financial factor, that could be the parenting skills, that could be so many other factors. Location. If the mother is living in the village, father is living in the town, then definitely court will feel that town is the best place for the growing children because of school, hospital, all the facilities. Okay, so there are so many considerations upon which a court will decide which parent shall have the custody, but both parents continue to share legal child custody until the minor has reached the 18 years of age. Legally they both will be custodian of the child. Okay, legally they both will be custodian of the child till the time child does not become 18. When she becomes 18, when she or he becomes 18, he will himself choose which parent he wants to stay with, and then no court can pass any order, because court can pass order only on minor children, not on major children. Court cannot tell any kid who's any adult to stay with any parent. Okay, if he doesn't want to, court cannot compel, but definitely court can compel a minor child, a child below 18, to stay with a parent. Restitution of conjugal rights, that is section 9. Okay, it says HMA deals with the restitution means restoration. Conjugal means marital. Restitution of conjugal rights means restoration of marital rights. If one spouse leave the company of other spouse without reasonable justification, court can order restitution of conjugal rights. Suppose a man and wife A and wife B live separately. Court can order wife to live with husband. Or if husband has left, court can order the husband to live with the wife. Something like this. Okay. If the parties do not follow the and if the parties do not follow such decree, if the court say that wife you have to live with the husband, but they do not follow it for 1 year, wife does not follow the court order, then husband can take a divorce on this ground that C, court has directed her to live with me but she is not living, then it can be a ground for divorce. Okay. Now we go on to guardianship. Okay, guardianship means custody. We go on to another portion, that is guardianship. Okay, guardianship of child. The Hindu Minority and Guardianship Act. The Hindu Minority and Guardianship Act deals with who is a minor and who is the guardian of such a minor. Who is the guardian means who will have the custody of such a child, who will have the control or supervision over such a child. That is Hindu Minority and Guardianship Act. Now it says guardian is a person having the care of the person of a minor. Person of a minor means person of minor here means body of minor. Physically the minor is staying there, okay? Or his property, okay? Either the physical custody of child or the property of the child or both his person and property, okay? So guardian is someone who is taking care of this thing. That is called guardian. In ancient Hindu law, the law relating to minority and guardianship is contained in smritis and commentaries of them. The Hindu Minority and Guardianship Act 1956 codified the law relating to minority and guardianship among Hindus. Codify means it has laid down the law in written manner. Okay, laid down the law in written manner. This act is a supplement to the Guardians and Wards Act 1890 and overrides Hindu law and customs. Now, this act overrides Hindu law and customs. So, now in this case, if there is any custom or there is a law which is going against the Hindu Minority and Guardianship Act, then the law will prevail. Okay, custom will have to go. Hindu Marriage Act allowed custom and law go hand in hand, but here only law will prevail, custom will not prevail. Hindu Minority and Guardianship Act (HMG) Act categorizes guardians into three classes. There are three types of guardians as per the Hindu Minority Guardianship Act: natural guardian, testamentary guardian. Natural guardian is definitely parents. Testamentary guardian is guardians appointed by will of mother or father. Testament is will. Testament is will. Okay, guardians appointed by the will of father or the mother. De facto guardians, okay, and guardians appointed under or declared by court under Guardians and Wards Act. De facto guardian means which people will, as a fact, they have a custody. Okay, as a fact, they have a custody. That means relations, near relations. Okay. Now, who is a minor? Okay. The Indian Majority Act 1875 considers a person who attains majority on his completing the age of 18 years. Persons below this age have guardians appointed by the court. Persons who are below this age will have guardians who are appointed by court. If they do not have any natural guardian or testamentary guardian, then the minor will get the guardian appointed by the court, de facto guardian. Okay. Hindu Minority and Guardianship Act defines minor as someone below 18 years of age, physically and intellectually imperfect and immature, and hence requiring someone's protection. Okay, if someone is below 18 and healthy, he is minor. If someone is above 18 but mentally unfit, okay. Now let us see types of guardians. What is a natural guardian? Okay. Section 6 of the Hindu Minority and Guardianship Act 1956 defines the natural guardian of Hindu minor. Who are the natural guardians of Hindu minor? Hindu minor. First guardian. Who is the first guardian? For boy and unmarried girl, father followed by the mother. These are the categories of natural guardians. Okay. First guardian is father. Boy or unmarried girl, father is the first guardian. Followed by mother. If father is not there, then mother is the guardian. Okay. First guardian is father. If father is not there, then mother. Clear? Minor less than 5 years old. If minor is there, but the minor is less than 5 year old. Custody is normally with the mother. In such cases, the father is the guardian. Minor who is less than 5 years old, guardian is the father, but usually custody will be with the mother because minor less than 5 years old requires a great deal of time with mother. Okay, though the guardian, first guardian is father, mother is second guardian. But if he or she is below 5 years, then the guardian will be father only, but custody will be with the mother. Illegitimate boy or illegitimate unmarried girl. Okay, a child who is born. What is illegitimate boy or girl? A child born without marriage, a boy or a girl born without a marriage is called illegitimate boy or child. Who will have the custody of such person? Mother followed by the father. If the child is illegitimate, the mother shall have the custody. Mother will have the first guardianship. Guardianship, mother will be the first guardian, and after mother, it will be father. And for the legitimate child, father shall be first guardian, followed by the mother. These are the categories within the natural guardian only. Married girl, legitimate or illegitimate. A girl, whether she is a legitimate child or illegitimate child, after marriage, her custody will be, her guardian will be, natural guardian will be husband. Husband will be natural guardian after marriage. Adopted son, when the son is adopted. Okay, the natural guardianship of an adopted son who is a minor passes on adoption to the adoptive father and after him to adoptive mother. So if some adoptive son, let's say adoptive child, so someone is adoptive child, then the same rule will follow. Adoptive father will be the first guardian and the adoptive mother will be the second guardian. The natural parents cease to be the natural guardians. Okay, the natural parent of this person, this adopted child who has now gone into adoptive family. This child had natural parents definitely. Now these natural parents will cease to be his natural guardians because after adoption they have no link with the child. Now they shall be removed. Okay. Now natural parents will cease to be guardian. Okay. They are stricken through. They are removed. In the case of death of adoptive parents, now adoptive parents have died, though the natural parents are alive, but natural parents of this child are still alive, but adoptive parents have died. Still, necessary proceedings have to be taken under Guardians and Wards Act for the appointment of guardian. Still, they'll have to go to the court to get the custody of this child. Even the child is their own child, but they have given it in the adoption. But after adoption, the adoptive father will be the custodian and adoptive mother, and they will have no claim. Even after adoptive parents' death, they cannot claim the child. The father or mother ceases to be natural guardian if, okay, now we are discussing natural guardian. Father or mother will cease, okay, will stop being a natural guardian to such child when, if they cease to be Hindu. Okay, father or mother, or they can both cease to be guardian at the same time if they both cease to be Hindu. Okay, so if the father has ceased to be Hindu, mother will become guardian, or mother has ceased to be Hindu, father will become guardian, like this. They renounce the world, become vanprasth, become sannyasi, or that. Okay, if some parent has become vanprasth or sannyasi or renounce the world, he will cease to be the natural guardian. They are stepfather or stepmother. Stepfather or stepmother is not guardian. Okay, stepfather or stepmother is not considered a guardian. Okay, adoptive father and mother are adoptive parents and step parents are different. Okay, adoptive parents and step parents are different. Adoptive parents are natural guardian, but step parents are not. Step parents are not natural guardians, okay, because they are different. Testamentary guardians. A father or mother who is a natural guardian may appoint anyone else as a guardian by will. I'll just explain it with an example. A says, after my death, D will be guardian of my child. A dies, but mother is alive. Mother will become guardian. Okay, he says D will become guardian after my death, but his wife is still alive, so his will not come into operation because mother is second guardian after father. So mother will become a guardian. Mother dies, D will become guardian. This is called testamentary guardian. When parents in their will say that the custody of my child will go to this particular person. A father or mother who is the natural guardian may appoint anyone else as a guardian by will. The guardianship comes into effect after the death of the natural guardians. Okay. Testamentary guardians exercise the same power and limitations as natural guardians. Okay. The appointment of testamentary guardian will have no effect if father predeceases the mother. That means if father dies before the mother, then the appointment of testamentary guardian will have no effect. Why? Because mother is still alive, like we discussed. Okay, he predeceased his wife. That means he died before his wife. So his is alive, so she will be the natural guardian, and D will not become guardian. But shall revive if mother dies without appointing by will any other person as guardian. But now mother has died. Now D will become guardian. But before dying, mother made a will and said, C shall be guardian. Then C will be guardian. And D will have no role to play. Why? Because mother made the will now. That person can make a will who has the custody of the child or who is the acting guardian at that point of time. So mother was the guardian, okay, at the last time, so her will prevail over the will of the father who has died before the mother. A minor cannot become a testamentary guardian to another minor. You cannot appoint a minor as a guardian to another minor. Okay? Because minor himself needs a guardian. He cannot act as a guardian to someone else. Under the old Midakshara Hindu law, a Hindu father alone and no other had the power to appoint a testamentary guardian of his minor child. Under the old Midakshara law, mother did not have any power to appoint a guardian. Only a father had. Okay? Hindu mother could not appoint a guardian by will, and the management of minor's property went into the eldest male member of the family. Okay, management remained with the male members only. If the father has died, whatever is the left male member will have the guardianship. But now the law is changed. Law now allows mother to act as a guardian and also to appoint a guardian by will. Now the third category of guardian is de facto guardians. The Hindu Guardian and Wards Act 1890 listed de facto guardian. De facto guardian is any near relation or someone else. De facto means by fact. So by fact, near relatives are more close to the child. That is a fact because they are relatives. Okay, so they are de facto guardians. If there is no testamentary guardian, no natural guardian, then de facto guardian come into picture. Who take the okay? So if the de facto guardian makes an application to the court and court approve, he becomes a court appointed guardian. So de facto guardians are uncle, aunt, grandparents, sister, brother, etc. Okay, they are the de facto guardians. If the mother father have died but grandparents are still alive, they will be the natural guardian. They will be the de facto guardian. And if they go to the court and take court's permission as well, then they will become court appointed guardian. Okay, they will become court appointed guardian. Now, a minor has no natural testamentary or de facto guardian. Suppose mother father have died. Okay, they have not left any will. Child is small, he does not know any relation. Okay, mother father are living away from all relatives. He has no relative. Now what will happen in this case? In this case, in such case, court will become the guardian of such child, and court will appoint any person. Any person doesn't mean any person walking on the road, but any sensible person, any officer, or any person who will be willing to become the guardian and who has the capacity to act as a guardian as well. So, court will appoint such person as a guardian. Okay, we'll begin with the maintenance chapter in the next lecture. It is time we must close this chapter here only.